My name's Dan Shea. I'm a lawyer here at FH&P Lawyers. One of the issues we deal with in family law, and one of the questions that clients frequently come to us with, is what happens with the children after separation? And the answer to that depends on which law you're going under. In the Divorce Act, people talk about custody. In the British Columbia Family Law Act, people talk about parenting rights, parenting time, parenting responsibilities. The two are very roughly similar. I mean, custody usually involves who gets the children and who's responsible for making the decision. So there's a fair amount of overlap. People generally in British Columbia use the British Columbia Family Law Act because it's a little more fine-grained. It allows for a little more nuance in the way that the questions can be approached and dealt with. Practically speaking, in British Columbia, anyone who has had a child and who was together at the time the child was born is a guardian of the child. So if you and your former spouse were married and have now separated and had children during the marriage, you're both guardians. The bigger question, the more important questions really have to do with who gets to have parenting time and who's responsible for making decisions about the children. And the answer to that is both very simple and relatively complex. It's simple because the only test really is what's in the best interest of the child. It's complex because that involves a whole lot of factors and people can have very different ideas about what is in the best interest of the child. The Family Law Act sets out a number of factors to decide what's in the best interest of the child. That can mean looking at the children's health, their emotional well-being. It can mean looking at the nature and the strength of the relationships the child formed with the parents. And to some extent that can involve who was the primary caregiver of the child during the relationship. So that's often a factor that the courts will consider. Other things the courts will look at are the needs for stability given the child's age, the ability of the persons who are potential guardians to be looking after the child, so the ability of them to meet the children's needs. And that can become the case of a fair amount of controversy when parents have different ideas about how strong of a parent they are, how strong of a parent their former spouse was. That can often be the subject of applications in court, in fact, where people want to get expert advice about who's best equipped to look after the children. In the majority of cases, parenting time and parenting responsibilities are shared between the parents, and that's fairly typically the way things go. In some cases, people decide, you know what, my former spouse is perhaps not well equipped to look after the child. I want to do something to prevent them from having parenting time with the child. And those are cases where there might be criminal activity, drug or alcohol abuse, potential violence. Those are the sorts of issues where the courts will say we're going to depart from this shared custody or shared parenting time model and look at where one parent is solely the primary caregiver and the other one might just have no parenting time or supervised parenting time, or in some cases might have what they call access, which is simply being allowed to have some time with the child but not acting in a parental capacity. So those are the sorts of things that we help you with here at FH&P Lawyers. If you have questions about your parenting rights, your parenting responsibilities after separation from your spouse, please give us a call. Thank you.